Again.
Good morning and welcome to the subcommittee. I am Councillor Keddy and I will put myself forward for chair today. Do I have the support of my colleagues?
Yep. Absolutely, Chair.
Thank you. Item 2, do we have any apologies for this morning's meeting?
No, Chair. And would you like me to read out the housekeeping now as well?
That would be fantastic, thank you.
Thank you. Please note that this meeting is being recorded by the Council for live broadcast and will be published on the Council website for a minimum of 6 months. The meeting may also be recorded or streamed for live or subsequent broadcast by members of the public, although ultimate discretion in this matter lies with the Chair in case of disruption. For those in the room, please note that if the fire alarm sounds, please exit the building by way of the nearest available signed fire exit route and make your way to the assembly point at the War Memorial in the gardens opposite the front of this building. Finally, please can we ensure that background noise is kept to a minimum and mobile phones and other devices are turned off or switched to silent for the duration of the meeting. For those in the room, this includes turning off microphones and turning down the volume completely on your laptops. Thank you.
Thank you. Item 3, do members have any declarations of interest in today's proceedings?
None from me, Chair. Thank you. None from me, Chair.
And none from me either. We will move on to item 4, the protocol for public speaking at hearings. This was included with the agenda sheet for noting. Is everybody happy with the protocol for public speaking today? If there's any dissent, raise your hands. Okay, I'd say we're in agreement, which leads us on to item 5, which is the main item for today. This is the application for wiggle of 159 Old Christchurch Road, Bournemouth. I will ask each participant in today's subcommittee to identify themselves and state their role. Starting with myself and the members, I am Councillor Keddy and I will be the chair of today's subcommittee.
Good morning, I'm Councillor Steve Bartlett and I'm a member of this committee.
Good morning, I'm Councillor Chris Matthews. I'm a member of the committee this morning.
We are also joined by Councillors Flagg and Chapman Law as reserve members. They are not required to participate, but they may observe for training purposes. They won't take part in the hearing or the deliberations. So, from BCP Council, we have our licensing officer.
Sarah Rogers, Principal Licensing Officer.
Our legal advisor.
Good morning, I'm Linda Cole, Legal Advisor to the subcommittee this morning.
Our clerk.
Good morning, Michelle Cutler, Clerk to the Licensing Subcommittee.
And observing from Democratic Services.
Yes, Christiane Tan observing for today.
We are also joined by Timon, who is joining us with work experience.
Morning, Timon Zirk, observing.
Thank you. For the applicant, we are joined by
Taran Ojala, Managing Director.
Thank you.
Jaspal Ojala, MD.
Thank you. And objecting to this application this morning, we are joined by
Susan Stockwell, one of the objectors.
Thank you. So before I run through the procedure for today, could I just check that all persons who have given notice of their intention to speak have been identified, and any person who wishes to withdraw a representation or wishes not to speak has also been identified. If there are no comments or indications, I will take this as correct. So I'll now explain the proposed procedure and order of speaking for today's hearing. The licensing officer will present their report. Questions of the licensing officer by all parties will take place with members of the subcommittee to go first. The applicant will make their application. Questions of the applicant by all parties, members of the subcommittee to go first. The objector will make their representations. Questions of the persons objecting by all parties will follow members of the subcommittee to go first. All parties will be given an opportunity to sum up, with the party who spoke last go first. The hearing will then conclude. The subcommittee will deliberate in private with our legal advisor and clerk present. Notification of the subcommittee's decision will be given within the period of 5 working days, beginning on the day or the last day in which the hearing was held. The notification of decision will include information about the right of appeal as appropriate. I will ask all parties to confirm agreement on this proposed procedure or make representations. It's probably easier if anyone is in disagreement, raise their hands.
Yes, Chair, I'd like to have the opportunity to address you at the beginning to save anyone any trouble if you agreed with me, to request that you have an adjournment because we're in purdah. Can I address you on that?
You can, and thank you for raising that at the beginning. I have been advised by our legal support on this.
Well, may I still address you briefly?
Please be my guest.
Just briefly, I've noted the other objections, which I don't know who they're from, but I can see that they do focus in part on the discouragement of women from the area. And you have had, you know, evidence brought in spadefuls by me on previous occasions of the harassment and by another objector of harassment. And you've had feedback as well on harassment from your public consultation that your committees had made previously. I now see, and it's no personal slur on any of you, that this committee is made up entirely of men. And I would say that that does make it sensitive politically, and that the principle of adjourning, because it's purdah, should be considered very seriously by you all. Thank you.
Thank you for your statement. I have taken advice, and I do take note and take your points very seriously. The request has been considered. Licensing hearings are regulatory and quasi-judicial in nature and not political decision-making. The pre-election period does not prevent the determination of licensing applications. There is no legal requirement for a licensing subcommittee to be gender balanced, and the composition of the subcommittee does not in itself give rise to bias. And I'm satisfied that the hearing can proceed fairly today and that no party will suffer procedural disadvantage by doing so. The request for an adjournment is therefore, has been well considered, but I, on that basis, will be refusing, and we will proceed with the hearing today. Do we have any other representations prior to the stated procedure? Then let's continue. I would like to pass to the BCP Licensing Officer to present their report.
Thank you. An application is made by Well Hot Limited for the renewal of the sex establishment licence held at 159 Old Christchurch Road for a further 12-month period. The premises have been operating as an adult lap dancing club for the past 20 years, since they took over in 2006. They have had the benefit of a sexual entertainment venue licence permitting the live performance of nudity since legislation came into effect on the 6th of April 2010. The application made complies with relevant legislation, and the necessary site and newspaper notices were published in accordance with that legislation. As a result, 5 objections have been received. The applicant compiled a response to the objections, which has been provided as supplementary information. 5 complaints have been received since the last renewal, 4 from one person and 1 from another. All complaints were referred to the premises and were dealt with. None of the complaints related to the operation of the business, they were observations from the outside. Therefore, there has been no need for the licensing authority to conduct an inspection of the premises. Responsible authorities, as identified under the Licensing Act, were also consulted on this application and no objections were received from them. Thank you.
Thank you for your report. Do we have any questions for the licensing officer members? Do we have questions of the licensing officer from the applicant or the objector, please?
Firstly, and I haven't given any notice of this question, I think I heard that there'd been considered to be no need to inspect the premises and the operation of the premises because the complaints were based on the outside of the building. Well, I would just like to query that on the basis that what you can see from the outside may indicate issues inside as well. And I wonder, can I just ask whether that was considered through the chair, beg your pardon?
Yes, they were considered, but the observations from outside related to a crack in the building outside, which wasn't rendered necessary to go and inspect the operation, and some litter outside that was no evidence that it was actually associated with this premises. It was just outside the premises.
Thank you. Do you have a follow-up?
Yes, I did have 3 other points, but I'd just like to say that there seems to be some, Chair, that there seems to be some I don't know quite how to put this. Your officer and I don't seem to understand the term premises the same. My understanding of the term premises is that it is the building plus the curtilage, which is a small amount of land around it, and that's premises. If it's masses of acres of rolling parkland, that's not curtilage. But an area close to the building itself is premises. And I wonder if we could perhaps have some clarification on that.
I can answer that, Chair.
Please do.
When I talk about premises, I talk about what is included in the licence. So it's the premises licence, as we refer to in the Licensing Act, and the terminology that we use within the licensing authority when we talk about premises is the extent of the licensed premises and what's included within and what's licensed, not what is necessarily around. Obviously, if it impacts on the premises, then yes, but when I mentioned premises, I'm talking about the area that is licensed.
Okay, so not necessarily the land that is owned by the operators, just what is the aspect of that land that is licensed?
It all depends on the context in which I'm talking, but generally, when I talk about a premises, it is the remit of the licensed area. It can include the outside area, of course, because we have premises with external areas. It all depends on which way the context of the query is.
I would note that in a previous subcommittee, the outside condition of the premises was raised, that there was litter, weeds and general untidiness, and the subcommittee at that time did recommend that the premises stay on top of it to present a good image to the area. So I would just note that as we are touching upon it. Do we have any further questions or follow-up?
I beg your pardon.
We will come to your questions after the objector, if that's okay.
Yes, and I've given some very short notice of this. I'm just asking whether, and I can see from the pack of documents it's not there, whether it's still your officer's position that the Bournemouth policy was not resurrected, as would be the usual case in a judicial review, by restoring the position immediately before the BCP policy was quashed. Is that still the position?
Okay,
I'm still
so
not seeing any case law on that.
this has been raised in
Yes, it
previous
has.
subcommittees, and I don't believe that our position has or will change on this, but I will pass to our legal advisor to elaborate.
Thank you, Chair. So it's not the licensing officer's position, it's BCP Council's position that the new policy was quashed. That did not resurrect an old Bournemouth policy. And that's the position that we've explained and maintained for a number of years now. So nothing's changed.
And two other points, if I may. I note that and again, to the licensing officer through the chair, I note that the recommendation that other conditions could be made by your committee, you could grant on other conditions than exist at the moment, isn't part of the report. And I'd just like to make the point that I believe that that is available to you, but that if you spring some new conditions on the applicants, then in the interest of fairness, that they should have time to consider that and possibly adjourn for that, as I'm sure you're aware. So I just want to, the question I'm asking is, are you able to confirm that it is within the gift of the committee to add conditions to a licence granted today, which don't exist at the moment, and that in the interest of fairness on the applicants, because we don't want to be left with a position where they can challenge the grant of a licence, that an adjournment would be appropriate if necessary?
So my position as chair is that should we deem it necessary through our deliberations, can apply conditions if required. We have made recommendations, as I noted earlier, about the upkeep of the outside of the building. We also have previously conditioned the removal of certain iconography and imagery outside the venue. So we are comfortable to impose conditions, and it will be at our discretion to do so. I'll just pass over to our legal advisor for any elaboration on that.
Yeah, the subcommittee can impose conditions today if they choose to. Obviously, any condition imposed would be dependent on, what's heard at the hearing, and any conditions would be sort of appropriate conditions and proportionate conditions. It's all very hypothetical at the moment because you don't know what we're going to hear. We haven't heard from anybody yet, so you haven't made your own rep yet. So, but yes, certainly the chair and subcommittee can impose conditions. Whether we would adjourn because we're opposing a new conditions, no, that wouldn't be a consideration. If they think it's appropriate and proportionate to impose that condition, they would do so today.
Thank you.
Thank you.
Do you have any other follow-ups or questions?
No.
Okay, thank you for that. We will move to the applicant. Do you have any questions directly for the licensing officer?
Not directly to the licensing officer, just I don't know whether we can just slightly touch on the points raised by Susan,
We
or if you wanna
can't
wait till
cross-examine
afterwards.
or address other representations directly, but you will have an opportunity to add things to your representation when it's your turn.
Okay, we'll wait until
if
that point then.
That's correct, I believe. Okay, thank you. Do we have any further questions for our licensing officer? Okay, thank you. In which case we will move to the applicant to make your representation.
Thank you, Chair. We've given you the response to our objections. I hope everybody's seen that. I was fairly detailed in addressing every point and making sure that we holistically covered everything in there, so we don't really have anything additional to add on top of that, unless there's any questions from the committee towards us, which of course we always welcome any questions that you may have. Just very quickly, in regards to the cracks on the building, I think perhaps it might have been a question to the licensing officer, but that we feel that doesn't fall under the remit of licensing. If there was a structural issue with the building, that would be raised. All buildings have cracks in them. It's an old building, it's been there for a long time, but it's nothing that affects a building structurally. Obviously, it is our asset, so we would want to maintain it and look after it. But the crack on the front of the building is not something that we feel is any danger posed to public at all. In regards to the cleaning of the building, obviously that was raised, I believe, 2 years ago. I think it was a couple of years ago by yourself, Chair. We do get the building regularly cleaned and jet washed now. We've got a team of guys, we took that feedback on board, so we do get it cleaned fairly regularly now. Litter does get thrown in the front garden by people that are passing by. They throw litter over in the front of it, but I think it's fair to say it's in much better condition than it was a couple of years ago. We get it jet washed and de-weeded on a regular basis. They do sprout up pretty quickly, but we take decent effort to maintain it now. Thank you.
Thank you for your application. I appreciate that. So I'll move to questions of the applicant by all parties, beginning with members. Do we have questions of the applicant at this point?
No, Chair.
Okay. I will move to the objector. Do you have questions of the applicant via the chair?
I think that's working. Yes, just the one that's come up from the representation just made about the suggestion that there's litter thrown over and that it's cleaned regularly. I mean, I think it should be cleaned every time that the premises is open, not regularly. I mean, we don't know how often that is. And the idea that people walk along and then throw litter over what's quite a high fence at the front is a bit of a stretch, it really is.
Do you have that felt like more of a statement than a question?
To the applicant as a question, do you think it's reasonable for the committee to believe that people walk down the road and throw litter over your fence, which is quite high?
I'll take your response to that.
It depends on the area of the building. If it's over that fence in that front garden bit, then yes, they do. I know from our building it looks very high, but people do walk past and throw bottles, cigarette packets, etc. Now, outside the immediate vicinity of the front of the area, yes, people do throw cigarette butts in the front when they're smoking outside the front. But otherwise, people are not consuming any food or any product inside of our venue because we don't sell that. So if any wrappers or litter of that nature is there, that's not come from our premises. That's been thrown over or it's been blown onto the premises. Now, in terms of regular cleaning, yes, it is cleaned regularly. Is it every single night? No, because we're not open every single night. So when the premises is open, it is cleaned. We do have litter pickers for the staff members, and they go around normally when the club is quiet at the start of the night, and they go around and pick up that litter, because of course when the customers come in, we don't want a load of wrappers and rubbish thrown all over the front of the building for when our customers come in.
Okay, thank you. So if there are, do we have any questions of the applicant from other subcommittee members present? Okay, in which case we will move to the objector to make their representation.
Thank you, Chair. Really, I don't have anything to add to what's quite a full representation that you've got in front of you from me. If you give me the opportunity to, I think I've already had the opportunity to mention the other objections. And so really, I'd just like to reiterate that we're here again, got some new faces. But, you know, some of you have been here many times with me making these objections. And every time I bring you the law and I bring you indisputable facts, which give you the discretion to refuse these licenses. And I say again that, again, we have that situation here. It's perfectly reasonable for you to refuse. And I think if you have people applying time after time for sexual entertainment venue licenses in breach of the principles laid down in every licensing policy anywhere that I've ever read. And I haven't read all of them, but I've read lots of licensing policies for sexual entertainment venues. And really, you know, the location, as you can see from the, just breaches every principle laid down, including those by your committee, albeit set aside as a formal policy by the court, and by your predecessors when it was Bournemouth. This idea that you can just plonk a strip club wherever you like in a town without the surrounding premises and the nature of the neighbourhood being used to refuse, I really don't know where it's come from. It's perfectly reasonable for you to refuse today. It is very much in your gift to give back Bournemouth's nighttime economy to people who don't want to use strip clubs and would like men and women to be meeting on equal terms, not as customer and person providing sexual entertainment. Thank you, Chair.
Thank you for your representation. Members, do we have questions of the objector? Whilst I don't have questions, I would just like to note that we do not have a policy to breach or contravene. This is kind of an immovable object since the legal challenge to BCP's SEV policy a couple of years ago, where it was taken and overturned by judicial review. So there's no falling back to old policies. We have an absence of SEV policy. Now, what that means in real terms is we now lean heavily on the Miscellaneous Provisions Act 1982 as our legislative structure. And within that are 4 sections, which we consider primary legislation in cases like this. I would also note that we have not received representations from statutory agencies or bodies, which would certainly add additional weight. And my final note would be that the composition and character of the town centre is changing over time, and we may get to a tipping point where that has an impact. And I would remind the venue that the changes to character of our town centre may be incremental, but they are heading in one direction, and that is an increased residential density. So I hope that gives a bit of insight into your questions from a statutory point of view. Okay, so do we have any other questions of the objector? Then we will move to sum up with the party who spoke last to go first.
Well, Chair, I think the applicant had some questions for me. Is that no longer the case?
I just asked
Yeah,
for an indication,
okay.
and I didn't
make
receive
sure I
one.
wasn't missed out. In conclusion, just a couple of points that I think the tipping point was reached when the Citrus building was built by this council. They're your long leaseholders. They're residential, most of them. And I really don't know how many more people they're living right next door. The fact that I've heard it before that, oh, well, nobody else complained. But I've done enough conveyancing to know that if you start complaining about the neighbours, that has to be disclosed. So it's unreasonable to expect the people who've bought long leases in the Citrus building, which you, I believe, despite what your estates department told me recently, still hold the freehold of. They're your people, your residents, as well as all the other people living in residential premises nearby. So I really do think the tipping point came a long time ago, if there even was justification for it being there. I want to just finish on one last point, which I know, Chair, you've been a great pains to point out, is not to be it's something that's already been decided. The BCP policy actually said within it, this replaces the Bournemouth policy. They weren't done as separate documents. There wasn't, let's get rid of Bournemouth policy, and now we'll have the BCP policy, in which case I quite accept that the Bournemouth policy wouldn't have been resurrected. However, the wording in the BCP policy does say this replaces the Bournemouth policy, which means that you go back to the situation when you quash a decision, the decision to bring in the BCP policy, you go back to the position immediately before, which was that the Bournemouth policy existed. And I just want to finish with that point because it's tucked away in there in the BCP policy, and it's easily missed. So that concludes it.
Thank you. I would also just reiterate that we do not have a policy. The policy does not exist, and we cannot refer to it in any way. And we have taken legal advice on this at a number of subcommittees now. And when the policy was quashed at judicial review, it did not create a fallback to an old Bournemouth policy. What it's created is effectively a policy void, where we have to rely on other legislation, which, in my personal view, I would much prefer it if we had a policy, but we would have a very long road to walk now after that judicial review to reimpose. It's not to say it won't happen, but it does mean where we are at this point, we do not have a BCP policy to refer to. So I would like to close that particular point off at this stage. Okay, so we will move to the applicants to sum up if you have any additional items.
We don't really have any additional items as such. I think I'd just like to add that there tends to be quite a big weight on the objections towards sexual harassment, towards women not feeling safe in the area, how the venue only provides services for the satisfaction of men. However, there are plenty of female customers that come in and enjoy sexual entertainment services. There is not I don't feel there's a gender bias because the club is open to all. Anybody can come in and enjoy that form of regulated entertainment. That is the purpose of a sexual entertainment venue and the purpose of the sexual entertainment venue license. It is a form of regulated entertainment. That really is the only thing I'd like to close on.
Thank you. Would our licensing officer like to sum up?
No, thank you.
Okay, no problem. Okay, so given that all parties have had the opportunity to sum up, the hearing will now conclude. I will now conclude the hearing. At the end of this meeting, the subcommittee will adjourn in private with our legal advisor and clerk present to deliberate. The decision will be conveyed to you in writing, as explained earlier. The hearing is now closed. Thank you very much for attending.
Chair, would you like me to go into?
Please. Thank you for rejoining, everybody. We will now proceed on to item 6 of today's subcommittee agenda. This is the application for Seafront Mini Market at 18 Westover Road, Bournemouth. All parties have agreed to adjourn this item until the 13th of May 2026. I will ask the subcommittee members if they agree on this adjournment. Are we agreed?
Chair. Yeah.
Agreed, Chair.
We are unanimously agreed to adjourn this item until the 13th of May. We will now close the meeting and end our stream. Thank you for joining us, everybody.
Thank you, Chair.